Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello and welcome to our Curious Amalgam, the podcast from the Antitrust Law section of the American Bar Association. My name is Matthew Hall and I'm with my co-host Jeny Maier.
Hey Matthew, good to be here.
Today we're going to talk about the Middle East and Africa. We're joined first by Nicolas Bremer to discuss Middle East developments. Nicolas is a good friend of the podcast. He's already appeared in episodes 231 and 328. So thank you for coming on again.
It's a pleasure.
So Nicolas is a partner with the regional law firm Bremer. He heads the firm's antitrust and M&A departments, oversees the firm's Riyadh and Cairo offices. So Nicolas, we're going to have a brief discussion today on Middle East developments. You've identified some countries we're going to talk about. So could you just take us through, firstly, what we should know about UAE developments?
And the UAE was interesting last year because it was a largely dormant jurisdiction, both from a behavioral antitrust side as also merger control. And in April 2025, they switched their merger control regime from a entirely market share threshold notification regime to a turnover-based threshold, and that has significantly expanded the scope of the regime and has created quite a lot more activity in the merger control space. There have been a good number of filings so far, and the authority is sort of dealing with getting to grasp with that. And that has also affected a little bit the behavioral side. So the authority has not just been dealing with more merger control filings because of the new thresholds. The new thresholds were coming in sort of a larger reform process that also involved like them becoming more active overall.
What type of regime is it on the merger control side? Is it a arrangement where you would engage in pre-notification with the agency, akin to a lot of the jurisdictions in Europe, or is it just you submit your notification form without pre-notification?
Based on the law and regulation, it should be the second. Mm-hmm. However, the authority has a little bit of an issue with the review period. If it expires, transactions are immediately considered as opposed to, and you would have to appeal that decision. That has led them to implement in practice a more substantial pre-notification phase, although it doesn't exist, both on part of accommodating sort of parties' capacities to clear a transaction through the normal procedure, as well as the authorities' inability right now to run through certain transactions at a speed, because they're still in a nascent phase. They're building capacity, and also they're dealing with staffing shortages. So they have, in practice, implemented a pre-notification phase to accommodate that.
Interesting.
And what about in practice in terms of filing? What kind of key practical difficulties and issues do you see when doing these?
The authority, although inexperienced, is quite pragmatic. So they are aware of the challenges that they're dealing with. Which is very welcome from our side when we're making filings. Of course, they have shown to be very engaging and open to listening to pragmatic solutions. The key challenge is the timing item. As I said, they're still dealing with staffing issues. Staffing issues they're very much aware of, and they're trying to mitigate that. For one, they tried to hire additional staff. They reached out to firms for secondments to find a short-term solution. So they're actively working on it, but it remains to be the key difficulty.
Okay. And what about you mentioned a link to behavioral work. What have they been looking at on that front?
So far, and we'll have to see whether the current situation in the Gulf changes that maybe a little bit, but their first focus was, I'd say, more straightforward violations such as price fixing, and they haven't delved into more complex structures yet. But there has so far not been a specific sector or areas of specific considerations.
Okay, let's move on to Saudi. Obviously, Saudi Arabia, obviously another important Middle East jurisdiction for transactions and other work. What's happening there?
I mean, Saudi continues to be probably the most active merger control jurisdiction in the region. Behavioral antitrust, they're also increasingly active in, although a little less than merger control. The most recent changes were introduced with the now 5th version of their guidelines. They amended the notification thresholds for the merger control regime to include a requirement for target revenue in Saudi Arabia to trigger a filing in an acquisition. In joint ventures or joint control acquisitions, they follow very much the European Commission model of the two parents still being able to trigger. But they introduced with this a very sort of straightforward local effects test, essentially, as opposed to the more ambiguous test that they had before, which, for one, makes it easier to assess whether a transaction might require notification. On the other hand, obviously, gives parties less room to argue. On the antitrust or behavioral antitrust part, they have had first dawn raids. It started already in 2024, but they've continued sort of this more aggressive posture there. Similar to other jurisdictions, though, they're still focused on more straightforward violations, although RPM is becoming more and more of an issue in Saudi Arabia.
On the change in the merger notification thresholds, as I recall, the previous thresholds were set at a level that triggered filings for a lot of international deals, foreign to foreign in particular. What have you seen in terms of the trend in the number of filings that the agency is dealing with?
There's still, year over year, if we look at changes, there's still an increase in overall filings, and also still foreign-to-foreign transactions make up quite a significant share of the filings received. It's true that there is a little bit of a limitation as to foreign transactions because at this point, previously, the target didn't necessarily have to have revenue in Saudi Arabia to trigger in an acquisition. However, the target contribution to the Saudi revenues thresholds being met does not have to be that significant that it would exclude a large number of transactions. So it is still fairly easy to trigger. Whether the authority will address that to further narrow the scope, we'll have to see.
Interesting.
You mentioned dawn raids and RPM. It's interesting to hear about that. There must have been some shock to see dawn raids from a competition regulator?
It was initially, the dawn raids have not been as invasive as they are in other jurisdictions, I would say. But obviously, as a first sort of experience with that from a regulator, it has been quite a shock. They still rely more substantially on negotiations and other investigation tactics than dawn raids. They still remain the exception. But yes, of course, if the doorbell rings and there's somebody from the regulator, it does shock the clients.
And how does RPM work? Is it a per se or by object type issue, or are they analyzing it another way?
When we're talking about minimum price fixtures, it is a per se violation. And even if what they're trying to establish right now is more the lines in regards to non-binding minimum price regulations that could, similar to other jurisdictions, they're looking at incentives that might make formally non-binding provision effectively binding, and they're looking at that. Maximum price limits, they haven't taken a position on yet.
Okay, it's interesting to hear about that. So something that we might recognise in the EU and UK at least would be similar type of analysis.
Yeah, they and overall the Saudi authority does take quite a lot of inspiration from the European Commission.
Okay. Let's move on, finally, Nicolas, to Egypt, where I know there have been changes fairly recently on the merger control side, but I think you've said that the most interesting area really is behavioral enforcement.
Well, the Egyptian regulator has traditionally been much stronger on the behavioral enforcement side. So until 2024, they had a post-closing notification regime in Egypt, and that just brought very little attention to that regime. For one, because it was often not triggered, and secondly, there was just not much investigation or review happening then post-closing. So they have developed quite a lot of their capacity in the behavioral antitrust side. And in Egypt, we continue to see it being, although the regulator has never explicitly come out and said that, but it appears to be somewhat politically driven, because they're dealing quite a lot with directly consumer-facing issues or potential violations that might have impact on consumer prices, which is an overall trend in Egypt. As you might imagine, a developing economy, they're struggling with price increases, and there were quite a lot of pressures from the war in Ukraine and the impact especially on food prices in Egypt, and then the resulting inflation crisis. So investigations we have largely seen in markets that either consider staple goods, such as foodstuff, education, these type of areas, and that's also where the most fines were coming out.
If that's the case, I take it then that most of the subjects of these investigations are largely domestic or regional as opposed to international?
Yes, that's true. We see mostly investigations that are domestic or somewhat regional players. International firms sometimes get drawn in because they might have connection to that market through distributors, but then often they're not the primarily investigated party, but it might be the distributor or their local partners.
And what are companies doing about compliance? Is there becoming a compliance kind of culture? Are people putting in place programs, etc., or?
It is growing. Stronger with international companies that might have more experience from their home jurisdictions and educate their local staff, and we've been involved in those type of measures. But the Egyptian Competition Authority also has a quite active awareness campaign, reaching out to the private sector, but also other governmental authorities. So we do see a change in the culture. And we do see local companies becoming much more aware of compliance issues and ways to mitigate liability through compliance programs.
Okay, interesting. Well, thank you very much. We're recording here at the spring meeting. Have you had any particularly interesting insights or panels you've attended that you want to mention?
Regrettably, I had not had that much chance to visit any panels because of meetings.
Yeah.
I am, as every year, what is still on my calendar is the Enforcers panel. I'm quite interested to see what's happening there.
The final panel on the yes.
I always like to find out what is your favorite thing to do here in Washington other than have meetings and visit with all of the international enforcers.
Typically, so my routine when I leave Washington is I leave typically on a Saturday. Mm-hmm. And my favorite thing to do then is to take a jog around the Washington Mall before my flight, sort of relaxed, especially because the cherry blossoms are coming in.
They are beautiful this year.
Regrettably, this year I can't do that because my son's birthday is on Saturday, so I have to hurry out on Friday to be back in time.
My son's birthday was just yesterday, so it's good week to have kids.
Well, thank you, Nicolas, for coming on our Curious Amalgam once again.
Thank you. It was a
to
pleasure.
speak with you.
Yeah, pleasure to speak with you also.
Thank you for being here.
Thank you.
We're pleased now to be joined by John Oxenham to discuss Africa developments. John is also a friend of the podcast, also having appeared in episode 328. John is the managing partner of Primerio, a Pan-African competition and antitrust law firm. John, welcome back to the show.
Thank you. Pleasure to be back.
So we're going to touch on today, firstly, quite material changes to the COMESA competition law regime. You can explain to us, but COMESA is, of course, a Pan-African, or at least a multinational regime of African countries.
Very much so. So for the benefit of the audience, COMESA is a regional bloc and comprises of 21 member states. It's been in existence principally from an enforcement perspective for the last 10 years. Ironically, the legislation which governs COMESA was drafted in 2004, so a lengthy period from an antitrust perspective, but of seismic proportions are the shifts which occurred in relation to their regulations. and those were implemented in December 2025, and resulted in quite noticeable changes in relation to enforcement, principally from a merger control perspective, and equally in relation to enforcement activities. And I think those are going to be of significant interest to the audience as a whole. We've already seen traction in relation to various of the regulatory changes, but I can run through those in some detail if you'd like me to.
Share some of the highlights with us.
Absolutely. Probably the most important from a transactional perspective is that COMESA is now a one-stop shop, and I think that's obviously of significant benefit to the international antitrust community, particularly those doing transcontinental deals and equally global deals. So what that means is COMESA has final authority in relation to the merger evaluation or merger review in respect of deals which have an impact across COMESA. Equally is that there is now an increase in relation to the merger thresholds, which I think is of some importance from a filing perspective, but equally there is an increase in relation to the filing fee itself to $300,000, which is the cap. Now, I think what's probably of some equal importance in relation to the key highlights is that from an enforcement perspective, so beyond transactional, is the introduction of a leniency regime. Yeah. And that's, at least from a practitioner perspective, to be welcomed. And comments made by the Commissioner himself very recently are supposed to be lauded, that there is this initiative underway to try and address anti-competitive conduct, particularly cartel conduct, which occurs across the continent and within the COMESA regime. So what that means is there will now be a leniency regime applicable across all 21 states. And that means if you are to apply for a leniency, as you would in relation to any corporate leniency policy application, you will have a leniency granted to you in respect of all 21 member states, which is certainly in keeping with the broader theme from a COMESA perspective, that there's a broader amalgamation in relation to enforcement, but equally in relation to transactional work, and COMESA fulfilling the role pretty much on par with what the European Commission has been doing for a number of years. Those are welcome developments from a practitioner perspective, but equally from an ease of doing business, so-called, in relation to the COMESA market as a whole.
How has that changed the way that you counsel your clients in terms of developing compliance programs?
Well, I think it's a very good question. Quite frankly, enforcement is on the rise across the African continent, and particularly across COMESA. It's a stated objective from the Commissioner himself that there will be, in relation to investigatory work, in relation to enforcement work, a robust approach in relation to cartels, and just more generally in relation to other restraint type arrangements. In counselling clients, I think you can no longer ignore the reality of that there is a leniency regime, that there's proactive enforcement within the COMESA market, and equally probably a sophisticated approach from the agencies themselves. So in counselling clients, I think it's incumbent on a number of those who have operations or businesses within COMESA to have the requisite programs in place, but equally to be aware of what the law says in those jurisdictions which are ultimately beneath the COMESA umbrella. So we generally have approached on the basis that you apply your standard dawn raid guidelines, for example, because there's also the mechanisms there. Equally, that you have the necessary policy documents within the organisation itself, which would ensure that there is pro-competitive behaviour within the markets themselves, and applying probably what's being utilised internationally across the African continent. And there's various mechanisms for that. The ABA obviously is one key component in relation to advocacy initiatives, which a lot of companies could borrow from. And we utilise those in relation to counselling clients.
Going back to merger control, John, you mentioned the one-stop shop. Is that operating well now in practice? Because in the past, I know it's been unclear, to say the least, as to whether it actually does work, and the individual countries do not also require filings.
I think there's a very strong element of emphasis from the Commissioner himself that COMESA is a one-stop shop, and that's been stated publicly on a number of occasions. We recently joined the COMESA Competition Commission in February in Livingstone in Zambia, where they launched the renamed COMESA Competition and Consumer Commission itself, the Quad C. But equally, the point made about one-stop shop was emphatic. I know there's been difficulties in relation to two jurisdictions in the past as to whether or not the principle applies, but from a COMESA perspective, it's been stated publicly, and certainly from the leadership within COMESA, that it is a one-stop shop, certainly in relation to transactions which meet the thresholds. So I think it's very emphatic from his perspective, this is Willard Mwemba, Dr. Mwemba, that from a COMESA agency perspective, they will obviously have a single filing in relation to transactions which meet the thresholds.
Okay. What are the other?
Despite, excuse me, sorry, Matthew, but despite the dialogue which has occurred with certain key jurisdictions within the COMESA, and there's no doubt there's been friction in the past, but from a statement perspective, it's emphatic from the COMESA perspective.
Okay.
Yeah.
One of the other changes I noticed, or maybe it isn't a change, is that there seem to be some additional public interest elements being considered in merger review under COMESA. I mean, of course, South Africa famously takes public interest elements into account. What is the situation with COMESA?
So within COMESA, which is a unique development again in relation to what's been taking place in South Africa, and I think the international antitrust community is probably very familiar with some of the difficulties which result in relation to moving beyond a pure SLC test in relation to merger control, one which includes socioeconomic goals and interests. COMESA have recognized those. And so those certainly are a feature in relation to merger control. Not to the same extent as it is in South Africa. I think South Africa, if one were to balance out the tensions in relation to a transaction, and to use this analogy, if a transaction, for example, is anti-competitive, it could still be passed on the basis that there are pro-public interest gains which result in relation to that transaction. That's not the case in COMESA, and they're quite emphatic in relation to that from an agency perspective, that the public interest criteria will not outweigh the competition assessment, so the pure competition assessment on SLC grounds. And so, for example, if there is a transaction where it's prohibitively problematic, the COMESA agency would not allow it on the basis that it satisfies those public interest criteria which is set out in the Act. So different to South Africa in relation to the balancing exercise which goes through. But an important development is that there is actually a recognition of public interest criteria for purposes of evaluating mergers and the review process itself. I think the Commissioner himself has said publicly as well that there is a danger of bringing in public interest criteria in relation to merger review. It's certainly one we've experienced, as you pointed out, Matthew, in relation to South Africa, that to some extent it's been a bit of a Pandora's box, that you effectively enable transactions to be hung on the basis of issues which have no nexus to the transaction itself. And I think that's a massive risk, which COMESA recognises, and they've stated objectively that that's certainly not going to be the case. There's a defined set of those public interest criteria, and the agency's explicitly not enabled the public interest criteria to outweigh these SLC tests.
What are some examples of those public interest criteria?
So there's some ESG issues, there's employment, very similar to what's been taking place in South Africa, which is understandable. I think why there was a degree of surprise, if you like, from a practitioner perspective, and certainly my perspective as to how these have been recognised, is that South Africa is unique. There's a reason why I think the public interest criteria could be implemented in relation to merger review, principally on the basis that there's been such significant unemployment in the country. And so the employment criteria, which is often a condition in relation to not just local mergers but international mergers, made sense based on the country's history. And equally from a growth perspective, if you look at where our GDP sits in South Africa, uniquely in relation to some of the COMESA member states, they're not bedeviled with those problems. And so I think the employment issue is probably going to be an overarching condition in relation to employment more generally, and equally some of the ESG issues, which are not too dissimilar to what's been taking place in Europe and the US in relation to certain transactions. So those are two which stand out, and obviously the impact in certain sectors, and more generally not too dissimilar to what takes place in South Africa. But those are a couple of examples which exist in relation to public interest criteria.
Very interesting.
Something else from the changes which caught my eye, which rings a lot of bells with an EU lawyer, were references to new per se prohibitions on vertical restraints within COMESA on absolute territorial protection, passive sales, RPM. Are these concepts familiar to, is it operating in a similar way to what you might see in the EU?
And I think that's the point. A lot of our clients obviously have operations across Europe. And as alarming as these new provisions were based on the previous set of regulations, so there was quite a volte-face in relation to the drafting of the regulations. The first iteration didn't contain per se prohibitions in relation to vertical restraints. The second obviously does. But that's not dissimilar to Europe. And I think the oft-quoted remark or comeback is that what's being done in COMESA is not different to what's being done in Europe. And so from a corporation perspective, particularly those worldwide corporations, this is not something which they can really bulk at from their own practices perspective and their own operations perspectives. We are seeing them being implemented. There are a number of investigations currently, some of which have been settled, particularly in the FMCG sector and in the alcoholic beverages sector, which have resulted in quite significant settlements being paid by certain entities as a result, obviously, of the implementation of these new restrictions. I think they're a good thing from a COMESA perspective, obviously in terms of bringing the COMESA market in line with what's been taking place in Europe. Slightly controversial, but I do think that they're ultimately not too dissimilar to what's been taking place in Europe, and I think that's really the short answer from a corporation perspective.
And Europe and the UK have been sort of at the leading edge of regulating digital markets. What has been any developments in the COMESA countries on digital markets?
So it's a very interesting comment was made very recently by the chairperson himself in saying that there's been a lot which has taken place in Europe and the US to some extent, but particularly in Europe regarding digital markets. To some extent, COMESA has fast-forwarded in relation to the way in which they're going to be evaluating digital markets. There's obviously the principles regarding gatekeepers. There's the principles regarding ex-ante regulation, which I think are fundamentally important in relation to how COMESA will handle all of these points. But from a digital markets perspective, there are certain provisions dedicated in the regulations to addressing digital markets, which means they're front and center. Ironically, and we mentioned this in the previous podcast, Matthew, in relation to digital markets, there were some significant penalties in West Africa. COMESA is obviously familiar enough to recognize the impact of these operators on the COMESA markets themselves, and the regulations obviously reflect that. So they're not, in the view of the Commissioner himself, and certainly from a practitioner perspective, they're slightly advanced in relation to what's been taking place in Europe. COMESA has probably fast-forwarded a little bit more in relation to its regulatory environment.
So John, outside COMESA, within Africa, are there one or two other key highlights you would want to mention?
I certainly would. I think from a South African perspective, going back to my home jurisdiction, there's been robust enforcement. We've recently had dawn raids which were conducted in the scrap metal market, which indicates a willingness to engage in robust enforcement from the agency's perspective. There have been a significant number of settlements which have occurred between the Competition Commission and various respondent parties on cases which in some instances have lasted 14, 15 years. An indication of trying to conclude on investigations is certainly the case from the Commission's perspective. From a transactional perspective within South Africa, there's certainly been a number of transactions filed, not, I think, which is more unique in comparison to the African agencies that we've been discussing. Equally, there's new agencies which are coming on stream with quite robust enforcement activity as well, and accepting transactions which are being filed by way of merger notifications. That's the East African community, and I think that's obviously a unique development in relation to more regional blocks that comprises 6 states. And what that means is that you're going to have potential overlap issues between COMESA, another regional block, the East African block, and I mentioned, just carrying on that theme, we've got CMAC and ECOWAS, all regional blocks. In the pipeline is obviously ACTFA, which is the African Continental Free Trade Agreement, which will provide another supranational agency of sorts, which will govern antitrust enforcement and developments. A lot going on the continent, quite simply.
Yes.
There really is. And I think all positive, certainly from a practitioner perspective and for entities wanting to do business across the continent. These are positive. These are bringing regimes in line with international best practices, sophisticated investigations and enforcement measures which are not too dissimilar with what's going on internationally.
Well, I think if we look forward to speaking to you again next year, you'll have more developments to share with us.
Definitely.
Well, John, thank you. As we usually end up wrapping up our episodes. We love to hear more about you as a person. What are you most excited about being here in Washington for spring meeting this year?
I think it's reconnecting with old friends. I used to live in Washington, I mentioned to Matthew in the last podcast, for a couple of years when I worked at a US firm. So reconnecting with friends is obviously a welcome opportunity, and equally digesting the latest and greatest in relation to antitrust as well. But there's no more beautiful city, I think, and it's a pleasure being back here. Thank you again for the opportunity to interact through the podcast.
Absolutely. Thank you
Thank
for
you,
being
John,
here.
for joining our Curious Amalgam once again.
Thank you.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.